Zoning Hearing Board will now come to order. Will the Secretary please take the roll?
Mr. Collins?
Here.
Mr. McDermott?
Here.
Mr. Walsh?
Here. Here. In accordance with the Pennsylvania State Sunshine Law, this board shall render its decision on each case either at the end of each hearing or within 45 days of the hearing. If you are to give testimony in a case, please come to the podium, raise your right hand, and wait to be sworn in. After being sworn in, state your name and address and proceed with your testimony. Also, anyone giving testimony who does not become a party to the case may obtain a written decision from the zoning office. I also have two announcements of law. If you are granted a variance or a special exception, you must wait 30 days from the date of our decision to obtain the necessary permits to start work. However, you may obtain a permit sooner by signing a waiver that any work done during that 30-day period is at your own risk. A favorable decision by this board shall expire 12 months from the date of said authorization. In accordance with Section 111I of the zoning ordinance, if you fail to obtain the necessary permits or do not comply with any or all conditions of said authorization, you must seek an extension. Any remarks from the board? No. And can we have an attestment to the verification of the postings? You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your name and address for the record, please? And Thomas, your title? Thank you. And do you attest that all postings were made in the necessary place? Thank you very much. We're ready for the first case.
Case number 1, Lamar Advertising Company appeals the issuance of building permit B 2011-0009 for a billboard located at 236-238 North Main Avenue, CN Zone.
Good evening.
Good evening.
Are you both giving testimony?
I won't.
Okay.
I see.
Raise your right hand. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
My name is Geoffrey McGregor with Lamar Outdoor Advertising. Our business address is 700 James Avenue, Scranton, Pennsylvania.
Thank you, Mr. McGregor. You can proceed.
Thank you. Appreciate the time before the board this evening. As you know, in several fairly recent appearances, we've expressed concerns about the proliferation of some of these wall-mounted vinyl ad displays in various areas of the city, particularly in spots where they are not a permitted by right use. So that's been a concern for us. The case in point is really more involving a location where my company, Lamar, had an existing sign at one point, which we dismantled last spring as part of a program. This particular location came to our knowledge probably back in late July, early August, when we happened to notice somebody installing what were the very beginning workings of a wall vinyl display on a building adjacent to where we actually had our signs. And upon further investigation, we discovered that it was a local sign company, Barletta Outdoor Advertising. And to our surprise, in examining a copy of the permit that we obtained for this job, it appears that this permit was submitted as a replacement for our sign location, because under the our sign that had been there at 232, 238 South Main had been a non-conforming grandfathered sign. So we removed it, and we moved on. But this particular permit was submitted under a section of the city code that provides for the replacement of a non-conforming sign if that replacement is constructed within 12 months of the period of time that the previous sign is dismantled. We don't have an argument with the 12-month period of time, because certainly our sign came down in the spring, and to our knowledge, the permit application for the sign was submitted at some point in the fall. What we do take issue with is the fact that the permit was posited and submitted as a direct replacement, in fact, for the Lamar sign, when in fact Lamar's sign was on an adjacent property. It was not on the property where this company has now installed its sign. So you might say, well, what's the big deal? Well, the big deal is if it cannot then, to our minds, be considered a direct replacement for a non-conforming use. It's a new use. It's on a property next door. Our other concern is it's also been constructed within 400 feet on the same side of the road where we have an existing digital sign at the corner of West Lackawanna and Main Avenues. So our concerns are twofold. I mean, and the only concern we have here, as consistent with any appearances we made recently before the board, is that everybody follows the same set of rules and regulations. The fact that this permit seemingly was submitted as a replacement for a non-conforming sign and then was actually reconstructed on an adjacent property where the Lamar sign did not exist was something that truly raised our eyebrows. I mean, we brought it to the attention of the city, and they were kind enough to say, well, if you don't agree with that, you have the right to appeal, and that is why we're here tonight. So, again, our two main issues are that this sign the permit was submitted as a direct replacement for a non-conforming Lamar sign that was removed, and the fact that this new sign being installed is closer than, it's 256 feet actually, from where our existing digital sign is on the same side of the road. So, what we're asking for is very simply, if someone's going to do this, that is a CN zone, a neighborhood commercial zone. Under the zoning ordinance, you can only install a billboard in a neighborhood commercial zone if it's within 150 feet of the right-of-way of the expressway or Interstate 81. Otherwise, you would need a variance. To the best of my knowledge, there was no variance granted for this sign. There was just a permit that was submitted that contained erroneous or perhaps even knowingly misleading information, and the permit was granted and the sign was built. So we felt that this was, given the fact that so many of these signs are cropping up, and particularly under the last administration, a few of them popped up under what we think are very dubious circumstances in terms of regulatory approval. We wanted to bring this to the attention, and that is why we're here.
Thank you. Now, your sign that was there, if I'm not mistaken, was a freestanding sign on steel structure?
Freestanding sign. There's an old Mercury Dry Cleaners is what it was called, dry cleaners there. That was their parking lot. Now, to be fair, the sign, our existing sign that we removed, was approximately 2 to 3 feet away from the wall of the building on where he has now installed his sign. So it was close, but it wasn't the same property, is the point. It's a totally different property. So I mean, in my own mind, I don't know. I've been doing this a long time. I don't know how you can say, hey, we're going to replace a non-conforming use, but we're going to put it over there. We're not going to put it where the existing non-conforming use was.
Okay.
Doesn't make any sense to me.
Any questions? No. Thank you.
Thank you.
Anyone else for testimony?
Attorney McDonough, no other witnesses?
No, Mr. Bennett.
Okay.
You can approach. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state your name and address and spell your last name for the record, please.
Robert Barletta, B-A-R-L-E-T-T-A, 1036 Scenic Drive, Clark Summit, PA, 18411.
You can proceed.
So we had submitted the permit And construction began, for the record, May 11th. The permit was submitted November. In November, it was approved, and we received the permit. So I had waited much longer than 30 days before we had began construction, almost 6 months. And I didn't hear anything from anyone. We began construction on May 11th. The sign was completely finished June 18th. And I have pictures to prove it. I believe the issue at hand here is that I thought the appeal period was only 30 days for anyone who has legal standing to appeal it. And the appeal application I have here is notarized as of August 9th, which is over 2 months from when it was completely finished
Dan,
building.
if you could jump in here, the appeal is on our variance approval or that, right?
No, there was no variance approved.
That's what I'm saying, so there is no appeal time on that.
No,
Okay,
any permit that's issued is subject to an appeal period, whether it's through the zoning board or a building permit that's issued.
And how
If the
long-
city issues a building permit and doesn't think it requires zoning board approval, and that, an aggrieved party still has 30 days to appeal it.
Okay, under our ordinance, under 111F1, it talks about a 30-day appeal period after zoning officer issues a decision, or in this case, a permit granted. However, 111F3 says the 30-day limit for appeals shall not apply to the revocation of a permit under 107F. Now, the only way that you could revoke a permit under 107F is if there was any false or misrepresentation of fact on the application for the permit. So, yes, there's a 30-day period, but there is an exception to the 30-day period.
I believe that's one. Are you done?
Yes. Yes, I am.
Thank you. I believe that's the primary issue here, is that I thought for someone to have legal standing, I'm not sure if they have legal standing or not. I don't have my attorney with me tonight, but I'm not sure if they have legal standing, but I thought the appeal period was 30 days. It was beyond 30 days, so that's the first thing. And the dates, I just wanted to put on record, like I said, we had received the permit November of 2019. We began construction in early May, and it was completely finished on June 18th.
But I think the question that was brought up here tonight by the first, we'll say witness, was the fact that your permit, your application was wrong. You stated that you're going back to a non-conforming at 238 Main Avenue, I think, when the original sign wasn't on that property, it was on 236.
And so I was going to get to that. That was my next thing.
I don't think he questioned your dates or anything like that. I don't think there's any questions on the dates from the one who's doing the appeal, from Lamar.
That was a question, what was one of my questions, is I thought the appeal period was only 30 days.
Okay.
So I feel like they were beyond the appeal period. It's not like we put it up overnight and try to surprise everyone. In terms of the application, I was not misleading. I did not lie. I had checked it over again and again. I had worked with Mr. King on this before we had built it. He had approved it and was okay with it. I have pictures of before and after. In terms of the issue, in the original application, I had included a section of the zoning ordinance which says about non-conforming uses which can be replaced within 12 months, assuming it's in the same location. And this has been done previously in other locations, on Greenridge Street recently with another competitor, where Lamar had taken down a sign and another competitor had re-erected it within 12 months. Not exactly the same size, not exactly the same location, but very, very close.
Is it on the same property, though?
This right
want-
here is on the same property, and this is what I'm getting to. And I brought pictures for you guys. So, may I approach?
Please.
Thank you.
It's not all there, though.
Hang on one second, I can give you the mic.
Thank you, Mr. Gaddens. So the previous structures, as you can see, there's electrical meters. There's actually about 9 inches of grass after the building, before Mr. Delacave's parking lot starts, okay? And that 9 inches of grass is, from what I was told, is not Mr. Delacave's property. It may be an easement, I'm not sure, I don't have a survey on hand, but the previous structure that was there, if you look at the electrical meters that's attached to the building and the gas lines that are there in the grass, that's where the previous structures were. Essentially, inches, Mr. Mr. McGregor, I'm sorry, had said 2 to 3 feet previously. We're talking about inches here, not feet. I measured it, it's 9 inches of grass before that pavement starts. And that's where those previous structures were. Those electrical meters, which are also in the grass, are also within those couple inches. The gas lines, and these electrical meters and the gas lines are for this building, this property that I'm talking about. So I feel like we're dealing with inches. Like I said, I didn't bring a survey with me, but to Mr. McGregor's point, he said 2 to 3 feet. I'm not sure if he accurately measured. I'll give him the benefit of the doubt that he did measure, but it's not 2 to 3 feet. We're talking about inches. So I just feel like we're splitting hairs here. I feel like it's the same location, and I included the pictures and a section of the zoning ordinance to Mr. King when I submitted the application for the non-conforming use.
Thank you.
That's all I have for now. Does anyone have any questions? I just wanted to add one last thing about the appeal period. So, and not that it matters, but Lamar is a multi-billion-dollar corporation. I'm probably the smallest competitor in this market.
Well, I understand that, but hopefully a few years from now, you'll be that multi-million-dollar one on the other side of the coin.
Thank you.
You know, so we got to apply it evenly across the board.
Fair
right?
enough.
I can
Fair enough,
appreciate what
Mr.
you're saying, though.
Thank you. But what I was getting to is that I have seen them challenge previous small businesses from this area, particularly Mr. Adcroft from Birdhouse. And I just feel that I did not do anything misleading. I didn't lie. Like I said, I worked with Mr. King. I had followed all the rules and the zoning ordinance. And what I'm getting to here is, where do we draw the line on what can be appealed? So I've been in this market, in this business for a little over a decade, and I know almost every sign that was put up without a variance, which should have needed a variance, a sign that was put up that should have not been put up, that should have, like I said, needed a variance. And so can I go, start appealing everyone else's because they're beyond 30 days, so can I start appealing, signs that were put up 2 years ago from other competitors, which I wouldn't do, but I'm just trying to get to where do we draw the line on the appeals.
I think, if I'm not mistaken, the appeal isn't about your sign. The appeal is about your application.
Okay.
So you're in a tough business, and we know from sitting on this board, John and myself, for over 5 years, you're jockeying for positions that aren't around that much anymore in signs. So you're in a tough business. But again, I don't think Lamar is appealing your sign. I think they're appealing the application process on the sign.
Okay.
So, thank you.
That's all I have. Thank you.
Anyone else here to give testimony?
Just to have one or two minor points. We're certainly not looking to put anybody out of business. This gentleman has been fortunate enough to find a few good properties for himself, and more power to him. Our point is, as I mentioned when I first stepped up here, is the process. You know, we try and always follow the process. We expect everybody else to, especially when these are signs of a different nature. I don't want to belabor the point, but it's a lot easier to install these things and find places to put them than it is to do what we do, which is typically a steel monopole sign in a big structure. I mean, literally, there are hundreds of wall signs or empty wall spaces in this city. You can see these all over the place if somebody was, you know, of a mind to try and do that. To his application, I would say, you know, generously, you know, maybe he didn't quite realize what the nature of the application would be when he felt he could replace the non-conforming use. I don't have an argument with that. All I'm saying is, if you're in the sign business 10 years, the city ordinance is pretty succinct. I mean, if you're going to put up a sign in a CN zone or a downtown, the CD zone, where billboards are generally not allowed, you got to go in front of the zoning board. That's all we're asking. We're not asking for the sun, moon, and stars. We would ask it for him. We've done it for Birdhouse. I think we've done it for Joyce too. And generally speaking, there's been a lot of hearings all over the place where we don't even bother attending. It's only when there is some sort of a conflict that conflicts either with the location of ours or there's a bigger principle at stake. We feel quite honestly that if you're not going to look at this situation where it's literally reconstructing a non-conforming use on a property that has nothing to do with where our sign originally was, we think that's a stretch, and just felt we should point it out. To the last point, something the gentleman said about a sign that was reconstructed in a exact same spot, similar kind of situation. That was a Lamar sign that was on the wall down here at Shealy's Drugstore, which most of you have probably known. We took our signs down. There were structural problems with the wall, and we vacated that. We terminated the lease, and a subsequent competing sign company went in there and put them up. But having said that, they're pretty much, I think, the exact same size as what we had there, and they're in the exact same place. So you didn't see us complaining about that or you know, mentioning that the permit shouldn't have been given or anything. It was just, you know, you gave up one spot, somebody jumped in it. So totally different kind of situation. Same property, too, I might add. That's the biggest point to be made. So that's all I have.
Anyone else here to give testimony?
Mr. Chairman, on behalf of the city, since the city was the one who issued the permit, our position is not to dispute any of the testimony, but again, on the timeliness of the appeal. I notified Lamar on June 23rd that this permit had been issued, and if they wished to contest it, they had to take an appeal to the zoning hearing board. They didn't file an appeal until August 4th, which is 42 days later. The state planning code at section 914(1)A states, "No person shall be allowed to file any proceeding with the board later than 30 days after an application for development, preliminary or final, has been approved by an appropriate municipal officer, agency, or body, if such proceeding is designed to secure reversal or to limit the approval in any manner, unless such person alleges and proves that he had no notice, knowledge, or reason to believe that such approval has been given." Again, in this case, I've given Lamar written approval on written notice on June 23rd that this permit had been issued, and they didn't file their appeal until August 4th, which is more than 30 days, and I believe it's barred by the municipal planning code. It's section 914(1)A.
And does that supersede what we have in our book here?
It should be consistent.
It's consistent,
It should be consistent, yes.
but is it?
My feeling is that the state planning code would supersede our local ordinance.
But I'm just asked this because this could head farther down the road, but
I would say our ordinance is still in effect. I don't see that it would be cut out. by the MPC, because the 30 days is in both, the MPC and our local ordinance. Our local ordinance goes one step further as to the application, a false statement in the application.
Thank you.
With the board's permission, I'm Sean McDonough, I'm counsel for Lamar, and may I speak just for a moment? As it relates to this issue on timing, I would submit to the board that Mr. King, who's a terrific public servant, he and Mr. McGregor had gone back and forth. There were a couple of different emails as it relates to Lamar's concerns once they learned about the issuance of the permit. As it relates to Mr. King's representation to the board, that in his view, an email constitutes an official decision of the city, I would submit that that's a stretch. Mr. King sent Mr. McGregor an email after Mr. McGregor's prompting on a couple of things. So as far as the city is relying upon a technical interpretation of its ordinance, I think they should at least have a hard copy of a letter citing a particular provision of the city zoning ordinance from which that 30-day period would begin to run. In addition to that, as far as an equitable argument, my firm's been fortunate enough to represent the city in a number of different matters, and in an abundance of caution to assist in this appeal process, I had a conversation with Attorney O'Brien. I certainly didn't ask for any waiver of any 30-day appeal period, but I have a letter in my file which reflects a conversation that, and as soon as it became known to us that Mr. King had no intention of revoking this permit, and once again, whether or not that constitutes an official decision is up to the discretion of this board. I had a conversation with Attorney O'Brien and said, I'd like to represent Lamar. Do you have any issues as it relates to a conflict? It took Attorney O'Brien, I don't know, maybe a week or so to get back to me. We had a conversation on, I believe it was Friday, July 16th, that the city had no issue with my representation of Lamar. As a result of that very following Monday morning, I'd sent a letter dated July 19 to Attorney O'Brien memorializing the fact that there was no conflict and no impediment to my firm filing that formal appeal. So I would submit under these circumstances, they're unique, and that, under equitable principles, a merits determination is always preferable to hanging something on a technicality, particularly in light of the fact, and Attorney Penatar has already cited to that provision of the ordinance that talks about, fraud in an application is strong language. And again, I'm not here to denigrate Mr. Barletta or his business. But just as Mr. McGregor had said, when you make a representation that you are replacing a sign, when in fact you negotiate a new lease with a new property owner, you're not replacing a sign. You've created a new land use relationship with a distinct owner, and as a result, that constitutes the type of misrepresentation for which the board would be able to consider this under its own ordinance. Thank you.
Thank you.
May I add one thing? Just one last thing?
You're sworn in already.
So I just thought of this. So the issue here at hand seems to be of the non-conforming, erecting the non-conforming use of the same property. As I mentioned, the previous structure, to the best of my knowledge, was on my landlord's land, which I provided pictures of. I'm not sure if they provided a survey or not, but their main argument is that the new structure is on their old landlord's property. My argument is that it's not. I don't know if they provided you a survey, but how could they prove it since we're talking about inches? And in the one picture, may I approach? The one picture, they put it. think this might show it a little more clearly. If you look at this addition they put on the back, the legs of the back patio come down to the end of the grass, which to me implies that that's his property, this grass that we're talking about. So how do I know, how do you know that their previous structures were in the property without a survey, that were actually in the property, their old landlord's property that they're claiming, which seems to be the issue here? And without a survey, like I said, to the best of my knowledge, that's either an easement or Mr. Decker's land.
Thank you, Mr. Bartlett. Well, we have no way of knowing that without a survey. I don't know if you'd be interested, Mr. Barletta, I don't know if you'd be interested in if we could get Lamar to agree to table this and have a survey done of that land. Because right now, I mean, the only way we know, I can ask Lamar, who'd you pay rent to, and I'm sure their answer is going to be to the owner of that lot, which was Mercury Cleaners, if I'm not mistaken. So at that point, I mean, if they paid for years how long that sign was there, I would assume that was the owner of that land. Well, I mean, I don't know who's going to pay for that survey. So, I mean, that's between you guys to figure that out. I'm sorry, I couldn't hear.
Dan, what was the exception for over 30 days for the appeal that you mentioned earlier?
The exception is if any false or misrepresentation of fact was in the application.
Knowingly or not knowingly?
Doesn't say knowingly or not knowingly.
So Don, well, when he applied for this, the prior sign, you don't have any documentation of where that sign was before he did this?
Just the photographs that were provided.
So there's no record of the city of where these billboards, what property they're on, or nothing like that?
No, not that I had. In the section 702B that the permit was granted under, says an existing lawful non-conforming sign may be replaced within 1 year with a new non-conforming sign, provided that the replacement sign meets all three of the following: is not more non-conforming in any measurement than the previous sign, including but not limited to the height and total square footage. Well, there was 2 signs that replaced, and this was one. So it was definitely smaller. And 2, it meets the city building code. This was reviewed by our third-party reviewer that met the code, and the sign was issued. 3, in the case of an on-premise sign, well, this is an off-premise sign, so that wouldn't matter. I would say, again, our position is that it met those requirements.
On a different property.
It doesn't say.
If. But I'm just looking for clarification here.
Yep.
This is a tough one. This is like a coin toss case.
I'll show you.
If we're going to go that direction, the appellant has the burden to show it was on a different property.
So some sort of proof, you're saying?
Yes, they'd have to have some sort of proof, tax map number, old lease, something.
I'm sorry.
It's a different property, different parcel entirely. Now, in terms of the positioning of the sign, I have a couple of quick photos I'll leave with you here. First, this is the remnants of one of the I-beams from the structure. You can see it clearly in the pavement there. And it is right approximately there, because when we take our signs down like this, we usually remove them to ground level. We don't dig the footers out. And you can see it again here. I tried to circle it. That is the remnant. That's the footer. That was the beam that was closest to the street. And again, the sign itself had been in place for decades. So it's kind of hard to imagine that whomever owned the property on which he currently has his sign now, that somebody wouldn't have said something when the original owners of the sign, which I think might have been Park Outdoor, went and put the sign up. I mean, you can imagine someone might have come out and said, hey, you're on my property line, or you're too close. Very typical of the old Scranton neighborhoods where people built right up to the edge of their lot. But if you look at the photos I gave you of the I-beam, the remnant of the I-beam, that's approximately 3 feet out from the wall space. So just to kind of illustrate what I'm telling you.
What they didn't put in there.
Dan, can we have a clarification how we're voting on this, like a yes or a no? Is yes to agree with the appeal?
Yes was to agree with the appeal. And no would be to deny the appeal or disagree with the appeal.
Thank you.
I'll make a motion.
Second.
Mr. Collins?
No.
Mr. McDermott?
Yes.
Mr. Walsh?
Yes.
Mr. Gattens?
No. So we have a 2-2 vote?
Appeal denied.
No, I'm sorry.
Appeal denied.
No, hang on a second. I voted wrong. I changed. Yeah. Am I able to, my vote?
You want to revote?
Yes.
Revote.
Mr. Walsh?
Yes.
Mr. McDermott?
Yes.
Mr. Collins?
No.
Mr. Chairman?
Yes. By a vote of 3-1, the appeal has been upheld.
Yeah. His,
Yeah, so I could have them sign it.
case number 2, JBAS Realty seeks special exception approval for the change of one non-conforming use to another, manufacturing to 41-unit mid-rise apartment building at the former Prote Cigar building at 1015 North Main Avenue, R2 zone.
I can't hear you. Go to the microphone at least.
I'm sorry, can I move the easel back so it's sort of alongside the podium, or
Yeah.
is that okay?
Yeah.
Sure.
Yep.
Okay.
Okay, raise your right hand, please. Are you both going to give testimony? Okay. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address and spell your last name, please.
Matthew Walsh, I'm an engineer with Colwell Nagley Associates, business address 276 East Grove Street, excuse me, 276 West Grove Street, no, it's East Grove Street. Sorry. Clark Summit, PA 18411.
You just moved?
Last name is spelled W-A-L-S-H.
All right, could you go to the podium? And again, state your name and address, please.
Hi, I'm Amy Brakefield with BDA Architects. Business address is 200 Abington Executive Park in Clark Summit.
You sure?
Yes,
Okay.
I'm sure. Do you
Thank
need me
you.
to spell my last name?
What's that?
Yes.
Brakefield.
Thank you very much.
You're welcome.
You can proceed.
Also in attendance tonight from our project team is John Basiliga from JBAS Realty. JBAS Realty acquired a property at 1015 North Main Ave earlier this year, and it's better known as the former Avanti Cigar, Prote Cigar building, former manufacturing facility. And the intent is to renovate and restore the building for use as mid-rise apartments. We're anticipating to get 41 units out of it. So the project is sort of, there's existing parking lots. I'll throw this board up quick. This is sort of existing conditions on the site. North Main Ave is over here, and Foster Street is down here. We're going to reconstruct the driveway off of North Main Ave. Sorry, move that quick, please, sorry. This is a proposed site layout. Some part, the main entrance would be right here. About 54 spaces on the upper level, and then there's a lower parking lot in the back for some residents that would live on the ground floor or at this side of the building. There's 19 spaces down there. And we're here tonight seeking, oh, we can take this down. Here tonight seeking a, per section 806.G.2 of the zoning ordinance, a non-conforming use may be changed to a different type of non-conforming use only if permitted as a special exception by the zoning hearing board. The board shall determine whether or not the applicant has provided sufficient proof to show that the proposed new use will be equally or less objectionable in external effects compared to the pre-existing non-conforming use. And then it lists 6 different categories that the board, that it recommends the board consider to assess whether or not the proposed use is equally or less objectionable. If you want, I can run through those 6
No, that's fine.
quickly. Okay, all right.
Just a quick question. This
Sure.
is strictly going to be residential, no commercial?
Correct.
Now, Don, if I'm not mistaken, we approved this project a couple years back under different developers. Are we here tonight because that special exception expired? Or is it because of change in plans?
I think it's a new owner and a new developer, so
Okay.
I think whatever approvals were given before, they're asking for a new approval, special
Okay.
and I think the former project was commercial in
It
nature.
was commercial and the first floor and then residential throughout.
Yeah.
Okay. Go ahead, please.
Okay. Did you want me to go through the 6 criteria or just? Okay, all right. I'll turn it over to Amy. She'll go over, some of the planned exterior renovations, which I think are probably what a lot of people are interested in, and quick overview of the floor plans and the amenities that are planned in the building. Okay.
Sure. So I will start with the floor plans. I brought some images here for everybody to take a look at of the 3 floor levels. We're not doing any additions to the building. The building shell will remain as it's currently situated. However, we are upgrading the exterior finishes, and in some areas, repair work is necessary for the restoration of the existing building. So, as Matt had stated, we have 41 units. They're a mix of 2 and 1 bedroom units. There's also a very nice lobby space and a gym, as well as several outdoor areas, a couple different patio spaces that will be redesigned and redeveloped for the use of the tenants, in addition to the parking areas as Matt had described. It's about I think it's 23 2-bedroom units and then 18 1-bedroom units. Some of those 2-bedroom units are 2 stories. So the 2-bedroom units are outlined in the green. The 2-story 2-bedroom units are in the center area there, which is outlined in the orange. And then the rest of the 1-bedroom units are in the blue coloration there, as you'll see on the floor plan. Here's some interior images. It's a typical apartment image, and then an image of what the lobby space would look like.
What is the square footage of the smallest unit that you're putting in that building?
They're all over 600.
That's good to hear.
Yes. There's nothing underneath that limit.
Good, thank you.
And then some exterior views. We're trying to preserve the character of the existing building, and obviously it needs some help with restoration. So we're trying to work on making sure we maintain the character of the existing building, but also, our additions our modifications speak to the character of the original building while still having a modern aesthetic. So the front view here is from North Main. This would be from sort of the rear of the property. So if you were up close to where the existing billboard is and the expressway there, sort of looking down onto the property. Some outdoor space, as I said, for some of the tenants, some parking areas, outdoor patios, plenty of parking. And then this is the new main entry.
Yeah.
The ordinance requires 1.5 spaces per unit, so total of 62. We're proposing 73 total, so a little bit in excess of what's required.
Thank you.
There's a lot of existing impervious on that site from either slabs from old additions that have been demolished or old parking areas. We're actually addressing the stormwater requirements by reducing impervious. None of that pavement structure can really be saved, so it's kind of going to get all ripped up, and a lot of areas will be revegetated in the process.
Thank you. Anyone else here to give testimony in this case? Please come up. Good evening. Could you please raise your right hand? Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, to help you God? Please state your name and address and spell your last name.
Dorothy Gervasi, Gervasi, 1010 North Main Avenue, Scranton, PA 18508.
Thank you very much. You can proceed.
I've lived there for 14 years, grew up in the neighborhood, but our main concern is the traffic. Is there going to be a one-way entrance in, a one-way entrance out, double entrance, double exits? It's a very busy street. We're very happy to see something is being done finally, because it's, water is laying all over it. I've been watching it, taking pictures and so forth. But we're glad to see somebody is taking initiative to get it started and get moving. But our concern is the traffic.
Well, maybe we could have, could you possibly come up and address that?
We, so as part of the, so I guess to answer the first question about traffic flow, there'd be two, pull this up here. I don't know if, should I show the board or explain to the?
Explain to her.
Okay,
right
sure.
now.
There's, okay, we've got an upper parking lot here, so this would be a driveway, you know, one way in, or in and out, right? So you could come in and out off of Main Ave. 54 parking spaces up here, and then down here on Foster Street, there'd be 19 spaces. And this is also in and out. There's no connectivity between the two, because there's a big grade drop between these two, so it's not feasible to get, you know, for vehicles to be able to get up and down through that elevation change in that short distance.
Okay.
So,
This is what we're concerned about. We all live here.
Right.
And we have driveways.
right.
And getting out as it is now, it's
Mm-hmm. We did, so as part of this, because this is a state road under PennDOT's jurisdiction, to clean up the driveway, and we're shifting it slightly away from that retaining wall from where it sits now, but probably a couple feet. But that requires a permit from PennDOT, a highway occupancy permit. And as part of that process, we sent them like an initial scoping application with information about anticipated traffic based on, it's a group called ITE, and they, for different land uses, they, you know, based on number of units or square footage or whatever, you can estimate anticipated traffic. We sent that information to PennDOT along with a summary of the existing traffic on the road, and they did not request a traffic study as part of the permit process. That's normally where that would have come, that request would have come from. So we're not anticipating having to do a traffic study or anything.
Okay, because I
But-
see there's been work on the road. Have you started working on the building?
No.
Okay, because they've seen trucks at your lot and working on the road. I didn't know that. When you say they're mid-rise, what is a mid-rise? Is it?
It has to do with the height of the building, and it was kind of right at the low-rise or mid-rise, you know, like the difference between the two. And I forget what the cutoff was. I think it might be 35 feet in height, and this building might be just a little bit more than that. So I called it, I put mid-rise down on the application.
And how many people do you anticipate living there? Because like these days, everybody has cars, 2 cars, you know.
With 41 units, and 23 of them being 2-bedroom units, you could assume that there would be 2 tenants for the 23, and then the remainder, the 18, being 1-bedroom units.
When do you anticipate starting the project?
Hopefully as soon as all the required permits and approvals are in place.
I know it's tough, but, you know, when you look at it day after day after
Sure.
day after day, and seeing it change hands, I was very glad to see things happening there, and some of your people are in there, and his people are in there, and it's very good to see that action going on. I watched the guy clean all the bricks and replace the bricks and put those windows in with the last door.
Yeah.
And he was meticulous, and they're broke. So, you know, we're just neighbors that are interested in our neighborhood,
Sure.
preserving it.
Sure.
And they'll be glad, and as soon as we can get up, we'll put flags up as soon as you start. Thank you.
Thank you very much for coming up.
Yeah, we heard the stories before.
Anyone else here to give testimony in this case?
Make a motion?
Second.
Nope, I'm sorry.
Somebody coming up.
Stuff out of your way.
Please raise your right hand. You solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your first and last name and your address, and then spell your last name.
Francis D. Lesky, D-E-L-E-S-K-Y. I own the property at 1025 North Main Avenue.
You
Okay.
can proceed.
My property is approximately 12 feet, my building is 12 feet from the Prote Cigar building. We were used to having Prote Cigar there, and it's nice that Mr. Basiglia is going to finally get something going on over there. Of course, we have concerns. My concern is because I'm so close, there's no chance down the road that there's going to be a nightclub or any kind of mal-order business in there.
Now, his application to us is strictly for residential units.
Residential, okay. And what about that? Are we geared for low income or Section 8 or anything like that?
That's nothing we know at this time.
That's something what?
That's nothing we know at this time.
Okay, none of our business yet, okay. And any other exits or entrances? I didn't get a chance to see what they were showing here, but no new exits or anything going to be put in stairwells or anything towards the Foster Street side of the building? There is one way down the back by that parking lot that they're talking about, I think, but no, because there's a sidewalk that goes down.
So there will not be any additional exits on the Foster side of the building. There is currently,
This is a stairwell here, my home is here, so this won't be made into another exit?
no.
Because there's like a sidewalk that goes down
It's
there.
actually not in that location. This is the ground floor plan on this side. So
Right.
it is currently, the stairwell is located here, and we are removing that. We do not need it for egress purposes, so it will no longer be there. There will be no exits on that side of the building.
Right, and that's up front towards Main Avenue or the one in the back?
That's in the back.
Yeah, okay,
There are no stairwells on this side up closer to Main Avenue. This
Okay.
is an existing one. We are maintaining that. And this is an existing one. We are maintaining that.
okay, and I couldn't see the blueprint and the drawing before when you were saying this is the new main entrance. Where will that be?
It is located right here. So this is the lower level floor plan,
Right.
which is at grade at Main Avenue here
Right.
and at grade at the rear,
Right.
and also along most of this side.
Right,
This is the floor level above that.
right,
So this is where the new main entrance would be. It's sort of sandwiched in the center
Okay.
of the floor plan.
all right, that's all I wanted to know, so for the record. Okay, thank you.
Make a motion?
Second.
Mr. Collins?
Yes.
Mr. McDermott?
Yes.
Mr. Walsh?
Yes.
Mr. Chairman?
Yes. By a vote of 4-0, you've been approved. Thank you, and good luck with your project.
Case number 3, MI Equities seeks variance to locate parking for proposed 42-unit mixed-use/residential development at 715 Linden Street at a location greater than 400 feet, approximately 650 feet from the property, institutional general zone.
Absolutely.
All right, who's going to offer testimony? It needs to be sworn in.
Gentlemen?
Donald Mamano, President of MIMI Equities, 317 Linden Street, Scranton, Pennsylvania.
Want to spell your last name? Stay there. You're not done.
I'm sorry.
Spell your last name.
M-A-M-M-A-N-O.
Thank you, sir. Anyone else giving testimony?
Michael Muller, architect, Fancy Parsley Architecture. Business address is 233 Oakford Court in Scranton.
Okay.
Last name is Muller, M-U-L-L-E-R.
I'm going to swear both of you in. Raise your right hand, please. You solemnly swear that the testimony you're about, both of you will swear in. You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can proceed.
Members of the board, I'm Attorney Patrick Lavelle. I'm here this evening representing MIMI Equities LLC. And in this matter, as the application previously indicated, we're seeking a variance solely for parking. We're proposing the construction of an 8-story building to be located at, as what now, 715 Linden Street in Scranton, which is currently the former location of the Regan Funeral Home. So that will be demolished and the new building will be constructed. What we seek the variance for this evening is, as I said, is for parking. And we're going to present testimony and evidence which shows that the applicant has control of a 10-car parking lot on Mulberry Street in Cressler Court, which is approximately 500 feet from the site, and 2 vacant 40 by 160-foot lots in the 400 block of Madison Avenue, which are approximately 650 feet from the site.
Attorney Lavelle, hang on one sec. We're going to ask them outside to be quiet so we can hear better.
Okay.
Thank you, Mr. Walsh.
Mr. Mamano has just corrected me. There's actually 4 parcels, which measure 40 by 160 on the 400 block of Madison Avenue. So the building, which they propose to construct, and I think you have a rendering in the handout that you've received, would have approximately 42 residential units in it, and the proposal is that they get approval from the requirement, in other words, a variance from the requirement of having 1.5 spaces per apartment to 1 per apartment, because these apartments are only designed to have 1 person living in them. So at this point, what I'd like to do is to ask Mr. Mamano to come forward and to explain the information and documentation that he has.
As far as the parking?
Yes, sir.
So as you can see here, I shaded all of the University of Scranton owned parcels in purple. The blue properties are properties that I currently own in 2 different entities that I own. 715 Linden Street, the subject property right here, in the corner of Linden and Madison, between Moyer Court and Madison. 10-car currently improved paved parking lot on Cressler Court and Mulberry Street. And these are the 4 parcels I own on the 400 block of Madison Avenue. I believe it's 600 feet from corner to corner to this site. There's currently two buildings on it, 2 vacant lots, and a vacant lot behind it, which will be the parking area that will be improved in conjunction with the new construction building to service 715 Linden Street.
Mr. Romano, that parking would be strictly for your tenants,
Only for tenants in 715 Linden Street.
and they'd have access to all them lots.
Yeah, there are going to be 2 different lots. This one and this one. This is going to be combined into 1 lot, paved, and it's only going to be for the parking of that building.
And how would you control that, like with a swipe card to get in and out for your tenants?
Now, all my tenants that I have now that have parking, they have parking passes, so they have to register their vehicle with our office. They get a parking pass that reflects that, and we have a towing company that monitors it, and we couldn't not provide the parking for our tenants, because then they wouldn't want to live in the building, and we monitor it pretty closely.
Thank you.
Mr. Romano, would you give the board a little more explanation as to the content of the building?
Go back to the rendering picture here. You can see on some of the floor plans, I believe page 3. Well, 3 is the other elevation, or the other view of the building. And 4 is different elevations as well. So actually, the first floor, you'll see we have 2 commercial spaces, about 1,600 square feet each. I do not have any commitment to anyone for the commercial space. I'm really not building the building for the commercial space. It's a component in the mixed-use building that I think would add a lot of value to the residents living in the building, the tremendous foot traffic from the University of Scranton students that pass that building every day. I'm envisioning something like a coffee shop, bookstore, something along those lines that I think would be beneficial to the tenants and the residents and everyone in the neighborhood around it. The rear entrance, the residential apartments and amenities area, couches, study area, desks, stuff like that, just amenities for the people in the building when they walk in the lobby. They can congregate, study, go to class. The last page shows you the typical floor plan on floors 2 through 8, where there's going to be 6 apartments per floor. Four 2-bedrooms, 2 1-bedrooms. These units are going to be stacked, meaning they're going to be mirror images of each other going from floors 2 through 8. Very similar to other buildings that I've recently completed. I just did a 40-unit apartment building on 600 block of Wyoming Avenue, the Miller Lofts. Very similar construction, or at least layout of the floor with the windows, open floor plan. We also got a variance 2019 before the board for the approval of 1 parking space per apartment. Like I said before, I wouldn't be asking for that if I knew that it would be an issue with my tenants. Building's been fully occupied. I never have two cars for a 1-bedroom apartment. It's just not the type of people that I rent to, not the demographic of the young professional, the graduate students. They're lucky they have 1 car. They don't have 2 vehicles for an apartment, so that's why I felt it was appropriate to ask for the same forgiveness on this project for 1 spot per apartment. That's pretty much
What's your smallest unit? I asked the last one, what's the smallest
so
unit?
maybe Mike Muller, the architect for the project, can speak on behalf of that. I mean, they're all of legal.
Yeah, none are less than 600 square feet.
Thank you. This makes our job easier.
Mr. Mullen is the architect that has created these drawings, and I'm inviting the board, if they have any more questions for him regarding the architectural features of the property, please ask him.
Sure. We tried to create an aesthetic that was, consistent with the neighborhood and using materials that, blend in nicely.
It looks nice.
I think you prepared the application, or part of this application, talking about 42 units of residential and 3,200 square feet of retail? Is that the proposal? Okay.
The variance, we only seek variance for the floors 2 through 7 for parking.
Okay,
We can't make a representation as to what's going to be on the first floor yet because we haven't built the building and we don't know. This is analogous to what we did for 614 Wyoming Avenue, where basically what we did was we got the variance for the upper level floors, which are occupied by students primarily at the medical school. But in this instance, and by the way, that 614, the lower floors are still basically unoccupied.
Okay, but you don't have any proposal for parking for the,
We do not.
We intend to come back when we determine what the commercial use will be. And we won't occupy it or complete it until we come back to ask for that, if we need it, depending on, I might give it back and use the whole first floor as amenities for the building, I'm not sure yet. But if I am gonna occupy it for commercial purposes, we'll be back for the board to present that and ask for
So
a
there-
variance, whatever we may need to seek that approval.
there's no parking on the footprint of the, where you're building right now?
I don't think it allows for that, so the answer is no.
Okay.
There is metered parking up Linden Street, you know, for,
Well, you know, we can't go by that.
but as of now, I don't know what to do on the first floor and,
Well, I mean, speaking for myself, I'm fine with coming back if, you know, if and when the commercial goes in there.
and I may come back and say I'm gonna ask for a variance for 2 more apartments on the first floor, which would be less of a requirement for parking and maybe more in demand to the market. I just don't know yet.
Dan, what is the requirement for the parking? How far is it supposed to be away from the property?
I believe it's 400 feet.
400 feet, 400 feet.
And how far are we away again?
Some of them are 500 feet and some of them are 650 feet.
That's correct. But both of those properties are currently owned by, if not Mimi Equities, which Mr. Mamano is the owner of, then a related company, in which he owns them.
Yeah, everything on the 400 block in Madison is owned by DFM Properties, which is my company. I mean, they're all mine 100%.
Is there anyone else here to give testimony in this case?
Good evening. My name is Tim Hinton. I'm counsel for the University of Scranton. My address, I'm with the law firm of Haggerty, Hinton, and Cosgrove, 1401 Monroe Avenue, Suite 2 in Dunmore, 18509. So we are opposing the application for the variance. If you look at the zoning code for a variance, there's 5 requirements. And the 5 standards for granting a variance are: number 1, unique physical circumstances or conditions are present that cause an unnecessary hardship due to such conditions. That's standard number 1. Right now, the Regan Funeral Home is standing there right now with a sign out in front of it that 3,000 square feet of commercial space is available on the first floor. And the second and third floors are available for student housing. Behind that building is a parking pad. I don't know how many spaces you can fit in there. It's about a 60 by 60 foot parking pad. Number 2 standard for variance, and this is section 445-11 of the zoning code, is that because of the physical circumstances and conditions, there's no possibility that the property can be developed in strict conformity with the provisions of this chapter. Well, we all know that's not true. Number 3, such unnecessary hardship has not been created by the applicant. There is no hardship here. The property is fully usable. Number 4, the variance, if authorized, will not alter the essential character of the neighborhood. Well, there's no 8-story building there right now, but there are 2 daycares close by. And children are dropped off in that area, and there is a ton of pedestrian traffic. So what's being proposed here is a 42-unit apartment building, 8 stories high, with no parking lot on it at all. They are they're putting the building on the complete property except for the 5-foot setbacks on the side and the 10 foot in the front and the rear. And their plans, which are attached to their application, call for 2 commercial spaces, which also has parking requirements under the zoning ordinance. If you look at the second to last page of their application, in the zoning analysis box by their architect, they specifically state that 79 off-site parking spots are required, 79 for the 42 residences, and the 16 spots are required for the 2 commercial spots on the first floor, which they're not providing for. And I'll point out that the sites that Mr. Momano is pointing to, and I drove through McKenna Court tonight, which is to the rear of Madison Avenue, and I think that's where he's talking about. He owns some student housing there. They're very narrow lots, and he said that they're vacant lots right now. So I don't think they're approved for parking right now, and that's another process he would have to go through to get those spots approved to use that in this circumstance. But what I would point out to is that the mere showing of any economic hardship, he's here with financial motives. He doesn't want to be limited to that second and third floor of student housing. He wants an 8-story building with no parking at all for any of the residents in that building. And if you ever drove up Linden Street, the 700 block of Linden Street at 9 o'clock in the morning, you could see how many students are walking there with 2 daycares so close by, Elm Park and Country Day or County Day, right there dropping off kids. There's a ton of traffic. So with 42 units, with the students or residents of those 42 units parking 650 feet away, how much drop-off and pickups, unloading the groceries is going to be happening there to add to that traffic problem, the safety problems that are going to be present with that. And that's our concern. For those reasons, members of the board, we would ask that you deny this application requesting a variance, that the standards have not been met under the zoning code, and the representation that they're only seeking 42 units, 42 parking spaces, down 1.5 per unit down to 1, none for the commercial space, is not good, and they haven't met their burden of proof here. Thank you.
Scranton is going to challenge that this building isn't consistent with the neighborhood, when it's actually the exact building across the street, Leahy Hall on Linden and Jefferson, that I tried to imitate because I think it's a beautiful building and I think it fits well into their neighborhood and the building they just built. Secondly, about my parking being an issue, being a block away, I mean, the University of Scranton has the whole 300 block of Madison as a parking lot, which isn't even legal. It's gravel. So they're going to challenge my parking. I'm going to pave it. I'm going to have stormwater management. I'm going to do it the right way, and I'm going to monitor it. I wouldn't be building the building if I didn't think it was appropriate. I own 317 Linden Street. I have almost 70 apartments in the building, not one parking space. They park in garages. They do the right thing. None of my tenants go to the grocery store loading, unloading groceries. I mean, the daycare center, I think one of them was moving out on Jefferson Avenue. So, I mean, as far as being a drop-off and a lot of traffic, people coming and going with vehicles, I have over 400 tenants right now. They're University of Scranton undergraduate, graduate, and medical students. They barely use their cars. They walk to class, they walk downtown, they get in their cars and they have to go to Walmart or to go home to see their parents on holidays. So they don't really move their cars that often, and for those reasons, I don't think there's anything concerning about the parking situation that we're proposing.
Anyone else here to offer testimony?
Don, with these parking lots that are off, do they have to be approved for some kind of parking for that?
If they're in an ISG zone, which I believe they are, parking as a principal use is a permitted use.
What size are these parking lots again?
There's two lots that are 40 by 160, but I own 4 parcels that are next to each other, and I have two houses in the front. One of them is a rear lot that's currently used for parking, but the point is I'm going to improve those lots by putting in curbs, blacktop, striping them, stormwater management, go through all the right things to build a parking lot and maintain it appropriately. Thank you. Any question?
The only problem I have, you're asking us to approve something without us seeing these parking lots. We're voting blind on the parking situation.
Well, I think it would be contingent on the parking being done as per code. Is that right?
It is.
Yeah.
I think he's more concerned about the number of spots that you have.
Yes, I'm proposing 42 parking spaces that will be built as per code for the parking requirement, and we're asking for forgiveness from the 1.5 spot to 1 spot per apartment, and we're gonna come back at a later date for the commercial.
So how many spots are you saying that you will have in these lots?
42 spots designated for the residents of 715 Linden Street.
So we can make it at least a minimum of 42 off-street parking.
That does not include the commercial at all.
Correct.
We'll come back to that.
So let's look down the road a little bit. Where are you going to get parking for the 16 for the commercial? If you go commercial.
I think that's hard to gauge because depending on the tenant, the parking requirement might change. So if it's a coffee shop, the parking
So let's just
requirement-
say you need 10. Let's take it down to 10. Just conversation.
If I had a tenant that parking was that important and I thought it was a good fit for the building in the neighborhood, I would tear down one of my houses on the 400 block in Madison to increase the size of the parking lot.
Wow.
Yeah. For the right tenant, I would do that. Right now, to be honest, I might keep the whole first floor vacant. Not vacant, but not rented, and use the whole first floor as an amenity for my building, which I think would make it more marketable than it's currently going to be. I mean, I spoke to someone at Lackawanna Historical Society. They have a need for space. I mean, totally off the record, nothing committed, but if they needed something for their business, they needed more space. It's right across the street. They like the proposal, and I think for the right tenant, maybe Elm Park needs more space. Probably not. They have a big enough church, but I really don't know what the tenant's going to be. I mean, maybe the University of Scranton will love the building that's built there and they want to put their bookstore there and they don't need any parking for it. I don't know. But for now, I want to just take it off the table for commercial, focus on the 42 apartments I'm proposing to build, 1 spot per apartment, 600 feet away. I mean, the university students that live off campus or live on campus, they're parking on Ridge Row. That's 3,000 feet from the building that they live in. I'm looking for forgiveness of an extra 150 to 200 feet.
I'm gonna make it a condition that the 42 off-street parking be added to this. And obviously, the commercial space they would have to come back for.
And that parking has to be completed at the start of the project.
I'm okay with that. More than fair.
I'll make a motion.
Second.
Mr. Collins?
Yes.
Mr. McDermott?
Yes.
Mr. Walsh?
Yes.
Mr. Chairman?
No. By a vote of 3 to 1, your project's been approved, and good luck.
Thank you.
Thank you, gentlemen. Don't go away.
Take a break? Yeah. We're going to take a 5-minute break.
Thanks.
Case number 4, Kaiser Land Development LLC seeks variance to install 2 off-premise signs at 1-3-5 South Webster Avenue, existing non-conforming manufacturing site, R1A zone.
I'm asking that the same 2 gentlemen who testified in the previous hearing also be sworn to testify in this one.
We're good? Dan, we're good on that? You're sworn in?
Okay?
We're good, already sworn in?
Yes.
Sal?
Yeah.
Oh, I'm sorry. I apologize. This gentleman is Sal Sermonero. He's also a principal of Kaiser, and I'm asking that he be sworn in.
Okay.
All right. My name is
Raise your
Sal.
right hand. You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your first and last name, your address, and spell your last name, please.
My first name is Salvatore Sermonaro,
CERMINARO, with Seminole Construction, 21 Franklin Street, German.
You can proceed.
Okay. We'd like to ask Mr. Amano to come back to the stand, to the podium.
He's the talker.
Can you tell the board about the project?
So this building, if you're coming into Scranton or leaving Scranton, you can't miss it, the two-story gray building. Jacobson Hat Company owns the building currently to this day. Their business is barely operating at that facility anymore. We're under contract to acquire it, contingent on approval here from the board. My partner Sal was in the self-storage business, still is. He has 2 other facilities. We spoke about the property, thinking about, different things to do with it. And it seemed to fit into his business model and something that I also like to get involved with the self-storage business. I think the location, close to the university, off the expressway, terrific visibility from the highway. And it's just, good solid building that Sal can speak for how many people come and go from the business in a day. It's not a lot of cars coming and going. Usually people's stuff, once it gets dropped off there. How often are your tenants
I had
come?
like basically 500 units up in Peckville and all in self-storage, and if you see 10 cars a day, that's a lot, and that's quite a bit, you know what I'm saying? So there's really hardly any traffic. Won't be any difference in the traffic count anyway. You wouldn't even notice.
Did we provide you gentlemen with renderings of the site?
Oh.
Sorry, I'm not sure that the application was for...
I thought we were here for a building.
Yeah, I thought...
I don't know if you need a variance for the actual building, for the self-storage.
You do.
Okay.
Was it advertised as both?
It's advertised as seeking to install 2 off-premise signs.
I think for the storage, I don't think there's any change in use right now. It's actually a warehouse and storage right now.
Hang on one
That's all we're gonna be
second.
doing.
Hang on one second. Don, we couldn't hear what you just said there, or Dan, whoever said it.
I'm sorry, no?
What was the advertisement for?
The advertisement says seeks variance to install 2 off-premise signs at 135 South Webster.
That's all we're here for on this one.
Yeah.
Yes, well, we wanted to say, what the background is before we talk about the sign, because it's going to be on top of the building.
I know, but you're talking self-storage too.
We just wanted to say what the use of the building is.
But you're here,
Do we need a variance it's a storage building now. Right now, the building
different
has...
type of storage building though. Am I correct?
Yeah, you would need a special exception to change from one non-conforming use to another, because you're in an R1A zone.
Somebody said we weren't aware of that. We thought we were only here to seek a variance for the billboard on top of the building. Mr. Penn.
And that's all that was advertised was,
I'm sorry?
that's all that was advertised was the billboard.
All right, if that's what we can do today, then we'll just go through the motions for the billboard. This is our intent, and then we'll have to come back to change the non-conforming use from one non-conforming to another. Is that right?
That is correct.
Okay, and it's got to be re-advertised, posted, so
Yes.
we'll do the billboard and we'll come back.
Is that okay with the board?
Well, if the billboard is going to be for the self-storage, then if you get the self-storage approval, you automatically get the billboard because it's an on-premise advertising side. If the billboard is going to be for something other than what's going in the building, then you need the variance for the billboard.
So what our intention was to ask for the board's approval for off-premise advertising. Neither one of us are in that business today, but we figured we most likely are going to use it for on-premise purposes, but we'd like to have the option if we wanted to rent it out or use a billboard for other purposes. I don't know what you say no about, but we're just asking for, permission to do 2 off-premise billboards on the building. We'll come back at a later date.
And
for the
that
building
is how
itself.
it was advertised, so, that is how it was advertised.
Yeah, so we'll continue that. If we choose to come back for the self-storage, if we have to, we will.
Thank you. We'll continue with this case for the billboards then.
Okay.
Okay.
So you're asking for 2 off-premise signs?
Yes.
For clarification, off-premise signs are signs that advertise anything that's not happening inside that building.
Yes.
Like a beer sign or...
Correct.
why doesn't this memento clarify exactly what's going to happen here? Because obviously, initially, they really want these billboards to advertise what's going to be in those buildings.
But he's also saying, Attorney Lavelle, but to rent the signs out too. So I mean, so we gotta look at it, I gotta look at it as an off-premise sign at that point there.
We understand, we acknowledge that.
And just to be clear, if we were granted the approval to do 2 off-premise signs, and then we use it for, we go back and forth, if we decided when we get the building up and running, we want to keep it for the self-storage, hopefully we're fully occupied, we no longer need that type of signage, and if we have a better opportunity to rent that billboard space out, I don't know how long it stays grandfathered in for off-premise or on-premise, if it mattered or not.
You gotta ask for either or.
Okay, so then we're here today to ask for 2 off-premise signs.
Correct.
Okay.
Correct?
Yes.
Yes. Okay.
Hey, could you clarify, are either one of you in the business of billboard advertising?
No, you're not.
Okay, and initially your intention is to do what we suggested before, advertise the self-storage, the ability to use the self-storage units in this building, and then if at a later date circumstances change, you would be allowed to advertise for off-premises advertising. Is that correct?
That's correct.
Yes, that's correct. And you know, Sal and I own various businesses. We talked about the idea if we had the signage based on the visibility on the expressway, maybe he wanted to advertise one of his businesses, maybe I'll advertise 42 apartments coming to 715 Linden Street. We just think we have enough businesses going on between the 2 of us that we might be able to use it ourselves or rent it out.
How big are these signs going to be that you're proposing?
You know, the size of the sign. I mean, I actually went on Lamar's website earlier just to see what size the signs are you see on the side of the road. From what I saw for those type of signs, 14 feet high by 48 feet wide, seems to be the signs that you see on the side of the highway.
And these are going on top of the building, on the roof?
Yeah.
And they're gonna be facing directly at the expressway, or are they gonna be angled?
I would imagine we have to get an engineer design, they're gonna be
Probably angled.
See,
Angled.
And they're gonna be, are they gonna be electronic signs or hardboard signs?
they're not gonna be electronic.
And they'll be lit up all night from say?
They'll
6
have uplighting at nighttime just so you can see them, nothing bright or obnoxious by any means. It's not in the line of sight while you're driving, you have to look up to actually see it.
So off the roof line, what's the total height of this sign gonna be?
34 feet, right? Is it roughly 10 foot of floor?
Yeah, it's probably more, I'm gonna say the sign would start at probably at 30 feet, probably go 30 to 40.
Okay. How wide did you say they are, an average sign, Mr. Romano?
48 feet wide, and we might not even go that big. I'm just going by what I looked at.
No, I
Lamar's.
guess that's what I said, yeah.
Yeah, I think the ordinance says the maximum height of a roof sign is 10 feet above the height of the building.
Okay, so then we'll stick with that requirement, 10
Yes.
feet from the height of the building.
Yeah, and the ordinance called for a billboard, a maximum of 300 square feet per sign when you're outside of a commercial district.
That's the maximum, 300?
300 per sign, yeah.
That's a 10 by 30.
Yeah, that's acceptable.
10 by 30.
Yeah,
acceptable.
we'll do that size, that's
Yeah.
fine. And like I said, we're not in the business, but something that'll catch your eye when you're going on the expressway is what we're trying to accomplish.
Okay, so on this rendering, there's one billboard sign. You're asking for 2. Where's the other one going?
The back side of the structure.
Okay.
So you see it coming into the city of Scranton on the expressway and while leaving.
Well, just for clarification, we would, permitting-wise, we would consider that one sign. One sign, you're allowed to have 2 faces, one each way. So it would be one sign with 2 faces.
Do they have to be attached to the 2 signs if they put one in the front corner, one in the back corner?
No, 2 attached sign faces. So we've take that to mean that they're on the same structure.
But I don't think that's what he's testifying to. He's saying-
No, we do. We both want to have both signs on the same structure on this
Okay.
point of the building.
Just angle.
Yeah.
Yeah.
Okay.
One you can see coming in, one you see going out.
Exactly. 10 foot by 30 feet.
Yeah.
Is there anyone here to offer testimony in the case? Please come up.
Sure.
Please raise your right hand. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your first and last name and your address and spell your last name.
My name is Archibald Lafferty, Lafferty, 739 Music Street, Scranton, Pennsylvania. We got this notice in the mail that, from the zoning board, that there were going to be 2 signs put up on this building. This building is located, if anybody knows where it's located, it's circled by houses, absolutely circled by homes. These signs are going to be visible for every home that goes around that building. That building's been there for probably 70 or 80 years. It's been used as a manufacturing place for Jacobson Hat Company. Now they want to switch it to another use. Also, we don't want to look at those billboards. It's bad enough we have to look at the factory, but we do not want to look at the billboards. Now, I owned a property on Meadow Avenue that had a billboard on it. I realized the amount of money you can get from the billboards. I had it for Lamar Signs owned it, or I owned the property, they had the sign on it. So I realized the amount of money you can get from it, okay? And I understand why they want to do it. But the unit block of South Webster Avenue is a dead end where this plant is. There's absolutely no parking there, none, okay? I drove down there today. There's 25 houses there on that street. It's a dead-end street. Music Street runs up the hill in the 700 block. Every one of those houses faces that plant. South Irving Avenue, every one of those houses on the end, there's 5 houses on the end, face that plant. We do not want to look at billboard signs. Now, I have 2 other neighbors here. If you want to hear from them, they could do it too. Now, when this was sent out, this is not descriptive at all. It says 2 signs. Is the sign like this? Or is it a billboard, 30 by 40? That's not right. Those people that got this letter, they have no idea. They think there's going to be a sign on a building. That's why there's no more neighbors here. Don't laugh at me. This isn't funny. This is our neighborhood. I just heard it.
Gentlemen, testify here, sir. Okay.
This is our neighborhood, and I'm here to fight for it. Okay? I don't want a billboard. I want it lit up. We had to put up with traffic, those trucks going into that plant for years. Now you're going to switch it to something else? I oppose it.
Well,
And I have neighbors here to oppose it too.
Just for clarity, we're only here for the billboards tonight.
I understand.
Not that rendering there.
And that's what I'm opposing, the billboard.
Okay.
Okay?
Very good.
Okay, thank you.
Thank you. Anyone else?
Pamela Kraft, K-R-A-F-T, 9 South Irving Avenue, Scranton, PA. My front porch...
Hang on a
Yeah.
second.
Oh, I'm
You're
sorry.
jumping the gun on me. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Now you can continue.
All right, now, as Mr. Lafferty stated, it says nothing about the size of the sign, whether it's going to be electric, where it's going to be placed, and my property on 9 South Irving Avenue looks right at the factory. Now, I have the lights from the University of Scranton shining on my house all the time. I have to listen to the noise from Polysolidor. Now, they're taking this factory storage unit that hasn't had any activity in the last couple of years. I'm there 32 years. They're going to turn it into a storage unit. And like Mr. Lafferty said, South Webster is a dead end, so is it South Irving. So people are gonna be coming in and out of that alleyway. They're gonna be disrupting the traffic flow. They're gonna make wrong turns. They come in my driveway all the time. I'm sorry. They hit my cars, and it was also brought to my attention, I know we're talking about the sun, but they approached one of the neighbors in the block wanting to buy the house so that they could drive the trailers down to that factory. So I'm here to tell you, we are tired of the noise. Conformity, whatever, that place is an eyesore. It would be better to be torn down than turned into another storage unit. We have enough of that stuff around the neighborhood, and I don't want it. I'm sick of it. Thank you.
Thank you very much. Anyone else?
Hi. Jerry Simrell, Simrell. I live at 737 Music Street, Scranton.
Okay. Please raise your right hand. You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please continue.
Okay. My house is on Music Street. The back of my house faces the factory that they're talking about. We all of us know that the need for people to have businesses and conduct businesses, but we don't need lights on all night long shining into our houses or need special things to block out what isn't there right now. It's a residential section. It's it's signs that are facing the highway, but it also blocks the view. I mean, it's, you know, you could put up a 60-foot wall around our houses too. It's not aesthetically correct, or it's not aesthetically pleasing, which is the purpose of these hearings, I really believe. So what Archie said and what she said, I totally agree with the whole thing, and I'm opposed to those billboards going on top of that factory, for the fact that my own house and all the houses going down the block, all of our neighbors, they're going to be inconvenienced by this blocking of our views and the lights on all night long. That's about all I have to say. Thank you.
Thank you, sir.
I'd just like to say, honestly, the sign, a 10 by 30 sign, if you're taking it up on this building here, I don't think anybody in that neighborhood would even be able to see it. Their line of sight, they're down at, whatever, let's just say they're at 10 feet in the air. They can never see that sign. And even in the back, I can't see how, if it's angled to the highway, I can't see how anyone would even see that sign.
Just for clarity, you keep saying in the back. Both signs are going to be on the same.
Yeah, but one sign would angle to the highway.
Right, but I'm just saying, I want to keep clarity, because when you say in
Okay.
the back, I got the impression first time it's going in the back of the building. Like, so I just want to
It's
be
the
clear.
back, yeah, it's
They're
all
going-
on-
They're both going to be in the, I'll say, the northeast corner of that building.
They don't have to be right on the end, they could be up in the middle. That's why I said it could actually be positioned where no one could actually even see it, unless you're on the highway.
Or you can't go too far back, or the highway's not going to see it either, so.
Well, the building's 400 feet long.
I know. Anyway, I mean.
Yeah, okay.
One other thing I just want to clarify, I didn't mention earlier. This building, we also are acquiring about a little over a quarter acre to a half an acre lot on Front Street, which when I drove by it yesterday, there's probably about 25 cars parked there by residents in the neighborhood. We want to be good neighbors. We're saying how terrible the building looks, nothing's been done to it. We're going to spend a couple $1 million to make it beautiful. We're not going to have these signs visible from people's porches. They're going to be 35 feet up in the air probably. And that parking lot that's a block away comes with this site. And currently, there's 53-foot tractor trailers that are going in and out of there daily, blocking the road, blocking people's access. I wouldn't want to live next to it either. I think what we're doing is we're taking something and we're going to have a lot less of traffic.
Mr. Mon,
But that's for another
that's another day. Let's stay with the signs.
Last question about the sign. If we didn't do off-premise, we could build that 10 by 30 sign and advertise our business in the building, right?
Mr. Pinatar, is that
Yes.
correct?
Okay, just so the neighbors are aware of that, we could put that there without coming here today.
Can I,
Sure.
where my home is, if I sit on my front porch, I can see the roof.
Ms. Kraft, come up to the microphone. Thank you.
If I sit on my front porch, I can see, I have a picture right here, I can see the roof of the factory. If I'm in my bedroom, which is located right there, I can see the whole roof of that building. And like I said, we have tractor trailers that park their cabs on the dead end of South Irving. Our parking is at an extreme there, and with what you're conforming for this building is going to increase it. It's going to make parking even more or harder for the people that live in the residence. I own 2 properties there, and they face that factory. Now you're proposing.
On the property right now, because I know the owner. I was just asking if she currently parks her vehicles in front of the building that currently is there, because the owner said that he allows the neighbors to park on the property.
No, I'm in South Irving Avenue, so I don't park down where the factory is. I'm saying when there's,
So what were you even looking at from South Irving? You wouldn't even see the billboard. It's on the other side of the building.
how are you saying it's on the other side of the building? There's the top of your building right there, and that's from my front porch.
Yeah, but that's the back of the building. We're going to be on this side of the building, on South Webster. You're all the way over here, 400 feet away.
Yeah, and then you were gonna put up a sign that big, that's gonna block.
On South Webster, not South Irving.
But it's still on top of the building. So my view of the city is gonna be obstructed by your signage. And I can't enjoy my property because you wanna construct the sign up there. Why can't you just put
Listen, this building was there before you were there, I'm sure. This building's 100 years old.
okay.
You chose to live there. I can't change that, but.
I'm sorry, I know I'm not at the microphone.
Okay.
Why can't you put the signs on the side of the building going up the highway? Why can't you put it over here as people are coming up off the expressway on the ground and everybody can see it?
Cars going down the expressway, they're looking sideways, and it's just clearly, straight ahead of them when they're going into the city.
But it's still, you're still coming in and you're creating another problem for our neighborhood with the increased amount of traffic. Now you're putting storage units in there. What's the hours of operation? When are the people going to be allowed?
That's the next meeting.
Okay, I'm sorry, but
That's
I guess,
okay.
I'm not coming back for the next one, believe me.
Thanks for coming to this one, though.
Yeah.
Dan, are billboards even allowed on the expressway?
On the expressway?
Are they
Or
allowed
on
to
this
face?
building?
Are they allowed to
To face-
face the expressway?
Well, billboards are not allowed in a residential zone.
To start with, right.
Yeah.
It's a residential zone, so the billboards aren't allowed to start with.
Come on up.
I'd like to address you one more time. This is a residential area, totally residential. I understand that factory was there before, as long as I've been alive, okay? But that doesn't excuse the fact that we don't want a billboard up on the factory. I'd ask one of you to drive over there and look at that factory and look at the neighborhood around there. Before you make any decision, please do that. And go up the alley and look at all the neighbors that can see those signs that they put on the building. Also, these signs aren't just going to be for their factory or self-storage. I guarantee you, they're going to be advertising other things on those signs for profit. Okay,
Well,
it's not going to be just for the self-storage, I guarantee you. This is just the foot in the door.
Well, what they're looking for is an off-premise sign. An off-premise sign is that that sign can advertise anything throughout the city, throughout the country, whatever, like a county fair or anything they could put on there. That's what they're looking for tonight, is the off-premise sign. So for clarity,
Okay.
okay? So, I will be abstaining from a vote tonight because I do own a property in the first block of South Webster Avenue there.
Yeah, I would like you to, please, one of you to drive up there, go around
You're
the
not
block.
listening to me. All right, so I will not be voting on this tonight.
Okay.
Everyone here drives to all the properties
Thank
on
you.
our agenda, so they
Thank you.
they have been out there. But I will abstain from voting tonight. Thank you.
It's come to my attention over the last week or so that PennDOT has to approve this sign if it's going to face the highway. Does anybody know if
Well,
that is correct?
we're here tonight to approve the first phase. If it has to go before, and I'm sure Mr. Lavelle, Ms. Mamano, Mr. Sarmento know that if there's another step in the process that they have to go through it.
Can this be postponed until they get a PennDOT permit to actually?
Well,
do it?
I don't know if they have to.
No, the first step
This
is
is the
getting
first
local
step of it.
approval.
Okay,
They
well then-
can't approach PennDOT till they have local approval.
Okay, so he just said that nobody could see the roof of the factory. Well, I can see the whole roof of the factory from my property on Music Street, and so can't everyone else in the block. So you can see the factory, I can stand in my yard and look over the whole roof of that factory. I can see the whole entire thing. Without a sign there, and I can see further. With the sign there, who knows? So I still stand in objection to the signage being put on there with the lights and in the residential section.
Thank you very much. Thanks for coming up.
I'll make a motion.
I'll second.
Mr. Collins?
No.
Mr. McDermott?
No.
Mr. Walsh?
Yes.
Mr. Chairman?
Abstain?
Abstain.
By a vote of 2-1, your application has been denied. Thank you.
Thank you.
Yeah, couldn't you put a banner, paint the building? Yeah, I'm thinking of put a banner.
Thank you.
There we go.
Ready? Case number 5, Con Properties LLC seeks variance to use structure at 615 Birch Street as 4-unit apartment building, R1A zone.
Raise your right hand. Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Please state your first and last name, your address, and spell your last name.
My first name is Vikram, last name Murgai, spelled M-U-R-G-A-I. Address 86 Seneca Street in Wilkes-Barre, PA 18702. The property at 615 Birch Street is owned by Khan Properties LLC. Ashmida, who is the owner of the LLC, isn't able to make it today because she's having a surgery. I'm standing for her. There's 3 legal units. When she bought the property, she was told there's 4 units on the property. She went to pay the garbage fees, and she was
Is it
made.
possible to take your mask down? I can't understand what you're saying.
Ashmida bought the property in August, and when she bought the property, she was told there were 4 units on the property by the seller. When she went to pay the garbage fees, she was made aware that the property is only zoned 3 units legally by the city from a hearing in 2017 in front of this board, and the seller misrepresented himself when he sold the property to them. So now, according to the zoning law, she is supposed to have 6 parking spaces to make it legally for 4 units. So I would like to propose the new parking structure that is being planned for that, so that we can convert it into 4 units. I would like to. You want a house out back? Yes. There's 2 units in the rear and 2 units in the front.
And you want to make 4 units in the front?
No, 2 in the front and 2 in the back.
Okay.
Right now, it's only zone 1 in the front and 2 in the back.
How long ago did you buy this place?
Pardon me?
How long ago did you purchase this house?
At the end of July, beginning of August.
Because this was before us before.
Yeah, Mr. Chairman, the new purchaser, as soon as they bought it, they came in to get it legally registered and pay the garbage bill, and that's when they found out it was only approved for 3 units. They were sold, told it was approved for 4.
Happens a lot.
And actually was occupied there were 4 units occupied when they purchased the building.
There were 4 leases on the property as well.
That probably happened the day after that we declined it last time.
Probably, yes.
You're saying you get 6 parking spots in the rear of that building, in between the buildings?
Correct.
I was back there today, and there's 4 vehicles parked in that lot.
Yes.
And that's about all that could fit, and there was 4 vehicles.
According to the measurements, we did the measurements, there's the back unit. If you can see, there's steps that go up into the back unit.
Yep.
If we remove them and make them on the side of the meters, that opens it up for 5 units, 5 parking spots over there, where you see 4 parkings. And then there's 1 more parking spot on the side over here.
On the side of what, the side of the front house?
This is the front house, and right there is the 6 parking spots.
So how wide is that lot?
11 feet by 22 feet. And the lot is 49 feet wide.
Since he owns both properties, he doesn't need a buffer on the sides of that, am I correct?
I think it says a parking lot of 6 or more spots
6 or more
doesn't
spots.
require buffer.
Right, and while he owns building 1 and building 2.
Yeah, that's what I'm saying, if he's abutting both his
It
buildings.
doesn't need a buffer between there. I'm worried about a buffer on the
On the yard side of the
upper
other
side
property.
there, whatever direction that is.
Is that parking spot on the side, on the alley side, or is that on the other side?
The alley side. See this? On the side of the house, where you have that 1 parking spot, what's the distance from the alley, like where your property line is, to that house?
It's 12 feet from the alley to the house wall.
The house, the alley to the house. It's 12 feet, 9. This one's like, 1.5, I can gap.
So there's a 1-foot retaining wall and 9 feet clear between the
That-
retaining wall and the...
The one on the side concerns me. Does he need a setback? Because he's right on the alley there, or the court, whatever you want to call it.
I think he's okay there.
Just the one on the alley I'm talking alongside the house. If it's 12 feet wide, he's taking up 9, so it's giving him basically 1.5 feet on each side of that car.
But he owns the building 1 on one side and the alley's on the other side, so
Sorry, if I can interrupt you just a second. Generally, cars are about 5 feet wide. The reason they give you 9 feet.
I'm going by the 9 feet required for your spot.
The requirement takes into account the opening of the doors, that's why it's designed to be 9 feet.
I'm not questioning the doors, I'm questioning if you need a setback from the alley. Like a
And you
legal
don't need a
setback.
buffer from the alley because the buffer is required where it's from a
Property line.
residential use.
I wasn't
The
sure if
residential lot
again, I
line.
wasn't sure if it comes, same thing as a garage where you required a pad.
Well, the garage is a building, so that has a different set of rules.
So that's a legal spot there then?
I believe that's a legal spot.
Okay. Two, three, four, five, that's 45. Got this thing in here.
What's over here?
At 6 cars, well, 5, well, I don't know if you consider that 5 or 6 in that back lot, but does that have to be paved?
I'm going to look at 603. Hang on one second. I believe it does, but
And we still got to look at a buffer alongside that property line.
603 E3.
It's still there. Nothing on the alley. This is the property line of the house. So you are.
Yes. The answer is a yes, it has to be
Has to be paved.
paved because it has off-street parking spaces serving 3 or more dwellings, which this would be. So that would have to be paved.
Okay. And then the second thing is we have to look at a buffer where they're pulling into that property, they're going to face that property line.
You're right. That's what I was more concerned with, was
Yeah.
that buffer. And I don't know, I can't tell.
So this is 615, so right next door or something.
Yeah, it's definitely a residence next door.
Yes. I can't tell by his drawing how many feet he has there.
Right.
Well, he has,
Well, we could probably tell by the building setback line. Maybe.
Sir, if you ask me, I can tell you.
so he's showing he has 39 feet from the alley up to, looks like the property line, or the house line. So, when I look at from the alley up to where there was some evidence there. It's like 30, he has 39 feet, 18 inches. So it's 18 for the cars, yeah. He has to pull 4 feet, it's a 4-foot buffer, am I correct?
8-foot buffer.
8-foot buffer. So he's taking them down, so 8, 18, it's 26. Did you remove some of the terrain from the backyard already?
No, we have not, sir.
Did you level it off some already?
Lot was leveled, yes.
So if this is approved, that lot will have to be paved.
Come spring, it will be paved. Cannot pave it because of the weather right now.
Right. And then you need an 8-foot buffer off the property line next to you for in the parking area.
8-foot buffer next to us?
Well,
Where the other residence is.
where the other residence next door, the property line that divides your house and the second house going up.
The second, there, right next to this parking lot, there is no house. They have another parking lot behind their property.
There's no house on that whole property from front to
There
back.
is, the house that they have ends before the building at one ends.
But it's their property, right?
This side is correct, their
Yeah.
property.
So you still need that buffer there.
So we are not building a structure, just putting cars there.
I couldn't, I'm sorry.
Just parking cars there, we are not building a structure there.
Well, I know you're parking cars there, but you still need a buffer between your property and their property.
Yes.
So you need an 8-foot off that property line coming towards the court, we'll say.
Yes.
I think he's asking for relief from that, and Mr. King brought it up on Google, and there are actually two parking lots.
Two adjoining parking lots.
Is it one lower?
Yeah, he's right on the alley.
Yeah, one's lower and one's higher, if I'm not mistaken. It's like about a 5-foot, 4-foot wall where they pull in. Yeah.
Right, but you come off that. You should be on top of this.
Yeah, you can give him 4 feet, and the next door neighbor has to have 4 feet too to make the 8 feet. Right. The next door neighbor technically, if the next door neighbor doesn't need a buffer if he's serving two units or less. If there are 3 units or more, then the next door neighbor does need a buffer. We can, yes, we have that right.
So we're gonna make it a condition of a 4-foot buffer, right? And it has to be paved, but we wanna make sure it's gonna be paved, Dan.
We can make those conditions.
So, give me a timeline in the spring. When would you say they can be able to pave that lot?
Snow melts in April, I would say before the 30th of June.
Could we add that date, Dan?
No later than June 30th? is that
Yes. I'll make a motion, did you ask if there's anybody in the audience? I'm sorry.
Is anyone here to give testimony in this case? And the buffer, it's a 4-foot buffer. That buffer requires some kind of blinders, like plants and stuff.
Yeah, he could talk to Mr. King about exactly what has to go in the buffer.
That buffer, Mr. King explained to you what has to be planted in there, just to stop the lights from shining up and going to people's houses.
Yes, sir.
So,
Like there's a retaining wall, and the retaining wall is 7 feet or 8 feet high.
yeah, we still need
So-
that buffer.
I will have the buffer, I'm just saying, because of the retaining wall, the lights don't
He
cross.
said the lights can't go.
I know, we still want the buffer.
I'll make a motion with conditions.
Second.
Mr. Collins?
Yes.
Mr. McDermott?
Yes.
Mr. Walsh?
Yes.
Mr. Chairman?
Yes, by a vote of 4-0, you've been approved.
Thank you, sir.
Get with Mr. King, and he'll help you out with the buffer and what you need to do.
Sounds good.
Thank you, good luck
Thank
with
you.
that.
Have a good day, sir.
One more.
Case number 6, Stephen Patrick seeks variance to build kitchen/bath cabinets and vanities at 1321 Steel Street, R2 zone.
My name is Stephen Patrick. I live at 1316 Steel Street in Scranton, PA, 18508. Last name Patrick, Patrick.
You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can proceed with your testimony.
Yes, I was just new at this. I wanted a commercial property. Right now, it's a R2 zone. I wanted to build the cabinets and vanities, etc. And I have my cousin is going to help me. It's just going to be a one-man show. It's not going to be a big corporation or anything like that. I'm retired from the Carpenters Local, and basically I want something to do.
Do you have a building on that?
Yes, I have a picture if you
To
like.
be honest with you, I'll take a look at the picture, because I couldn't find you today when I went over there, so. Yeah. You're being generous in the middle of the woods.
If you just go back to the microphone so everybody could hear you. There's an existing building you're saying that is already built for you to build these things in?
I'm sorry.
There's a building already you're going to be building these structures in? You have a building already that's already built?
The building is there, yes. Is that what you said?
Yeah. Is it in the picture?
Yeah, I own the building, and then all that.
What is it?
So is this the building?
Yes.
The tan-looking building?
How big is the building?
It's inside is 25 by 55, two-story.
Is there an apartment in that building?
Is there what?
Is there an apartment? Anyone living in that
No,
building?
no apartment. It's
Okay.
all wide open. It used to be the Scranton Sportsman's Club, and it was erected in 1929, and then rented to the AMVETS, the American Veterans, and then the Scranton Pigeon Club had purchased it, and I purchased it from them.
What kind of traffic do you expect in there for, like trucking, or you're having lumber delivered, or?
Hardly any traffic, and basically it's going to be friends, word of mouth, and maybe some small advertising in the paper. Pardon?
Deliveries for lumber and
My pickup truck, that's all. It's going to be, like I say, very, very small operation.
You're not going to have a showroom?
Maybe down the road, but not right now. If I do, I'd get a permit to probably remodel and make a showroom, if it turns out well. If it doesn't, you know, I plan on giving it to my nephew, but.
how about as far as hours that you're gonna be in there working?
It all depends. If I have a job, I may be there 5, 6 hours. When I get tired, I just close the doors and go home. I live across the street.
Well, I'm concerned about the noise, so I mean, you do have some neighbors around there.
There's two, and I question both of them.
I know, but I'm asking you, what's the latest you think you'll be working in that shop?
The latest, probably 6 o'clock.
And you said your neighbors, you talked to them, they were okay with it?
Yes. Lisa and Paul Mundy and Jeremy Cerebra. You can't even hear the saw running. If I turn the saw on and you stand right outside the building, you can't even hear it.
Well, there's no one here to give testimony. Any other questions? No. Well, I'm gonna put a condition on at the latest be 7 o'clock in the evening. Okay, so,
I don't know, Dan, would this be for this gentleman only? If somebody else tried to run a business in there, they'd have to come back?
No, we can't do that.
give you Sunday off.
Pardon?
We're gonna give you Sunday off.
I'm going to have probably 4 or 5 days off.
I make a motion with the conditions?
Second.
Ms. Collins?
No.
Mr. McDermott?
Yes.
Mr. Walsh?
Yes.
Mr. Chairman?
Yes, by a vote of 3-1, you've been approved.
Thank you.
With the following conditions as stated.
Thank you.
Thank you very much. Good luck.
Thank you.